and for the wonderful plug for all the other publications. And of course to Carla and Emmanuel for the interaction and feedback. And for reading the book. I really appreciate it. I'm really looking forward to it. I think we're going to have a great chat. And I think that perhaps before I give I'm going to try to give a very short introduction into what this book is about and what are my arguments. Maybe I could say why I wrote it, which is nowhere in the book. So before I joined academia, I clerked at the state attorney office. When I was working there, I was mainly working on cases like this, where you had plaintiffs. They were mostly, if not all, Palestinian plaintiffs, bringing claim against the state for various things that the IDF has done, and trying to find a remedy in tort. And case after case, I came across various arguments where the IDF has said, yes, we admit that we have injured these people and we admit that it was completely accidental, but they should get nothing from us because we have this immunity. And it got me wondering why this immunity exists. And the more I looked into it, the less I found in terms of a rationale. There wasn't much of a rationale in legislative history. There wasn't much of a rationale in court cases. The kind of ordinary spiel that came across was mostly a knee-jerk reaction of why states generally, not just Israel, but all states shouldn't have tort liability when it comes to engaging in warfare or combatant activities. And that is for either policy reasons. We don't want anybody to try and interfere with military decisions through tort law, or to try and limit our ability to act in some kind of way because there is this tort remedy. And the second was perhaps policy, perhaps theory, that tort law just doesn't apply. It's irrelevant. It's an ill fit for whatever happens on the battlefield. And I read these very short decisions. The longest one was a single paragraph. And the immediate response I had was, I don't know, I don't agree with this. I can see how. I can see how we can make an argument for why we should and could have tort liability in this context in some way or another. And just short 10 years after, we have this book. So perhaps it was too quick in my thinking to think how easy it would be to try and advance an argument of that kind. But I think that the argument could be made, and I think the argument should be made. And then the questions about whether or not to accept it are mostly within the realm of policy. So what is this book about? Like I've hinted, it's about the ability of domestic courts to review state action, even if it's through combatant activities, through actual engagement in activities, and provide remedies for individuals who were injured in that process. And my argument is that it's both possible, could be done using existing doctrine, but also that it should be done for a variety of reasons. So why do I think that this is something that can be done? So I start by articulating what would be a wrong in the context of warfare. And just to emphasize that there can be a wrong in the context of warfare. And the kind of wrong that I'm talking about is a private law wrong. So what I'm suggesting and showing is that private law rights don't disappear during warfare. They don't just dissipate because we engage in them. We don't lose our right to life. We don't lose our right to bodily integrity. We don't lose our right to property. And yet states can engage in all sorts of activities that would harm us. And the question is whether they should pay for those or not, and what would be considered a wrong, a private law wrong in that context. And you have some people that might argue that everything should be considered a wrong and states should pay for all of the losses they inflict on civilians. Some people will say that states shouldn't pay for any loss whatsoever. I try and articulate a middle path, saying that there is a narrow set of circumstances that could be a wrong. And those would be the circumstances where a loss would be not justified, And therefore, if a state inflicts that harm, it acted without proper authority. So the thought is this. If a state engages in warfare and injures somebody, then that would be a prima facie wrong. I can't punch it in the face, even I really want to in everyday life. And I can't do that if I'm a soldier on the battlefield just because I feel like it. There are specific sets of circumstances that would make this prima facie wrong non-wrongful. And that means that I need to act with the right kind of authority that I have as a soldier or as a state, which means that I need to comply with the laws of war, and I focus on jus in bello and the rules of engagement. So my argument here is that everything that falls short of being justified in that way would be a private law, or at least could be a private law wrong. There's a way of articulating what would that wrong be. The second point that I'm making is there are really good substantive rule of law reasons why we should translate this moral obligation into a legal obligation. And the point that I'm making here is that immunities from liability are what requires justification, a legitimate justification. The default starting point of every regime is that we should have private law remedies. And if we want to limit that, then we need to provide a proper justification for that limitation. And existing legislation in Canada, in Australia, in the US, in the UK, and in Israel don't really provide that legitimate justification. I don't think they're providing the right kind of reasons that would say that is okay to provide this kind of blanket immunity from liability in the context of warfare. So the onus of showing that we shouldn't have liability is on them, rather than the onus of showing that we should have liability is necessarily on me. That is one argument. And there are good, valid reasons why we should have it, because it helps to act as a bulwark against arbitrary and use of force and abuse of force by states. So there are good rule of law reasons why we should have tort liability. I then go into a variety of doctrinal issues to show why we could have tort liability doctrines operate in a fairly ordinary fashion, how we can have intentional torts, how we can have negligence, how we might deal with issues like vicarious liability or causation. And I'm not going to dive into any kind of particular details because that is very kind of nitty-gritty and mostly doctrinal, trying to flag how various pressure points that might arise can be explained or tackled or pushed back, particularly when it comes to the idea of duty of care, where at least in this jurisdiction in the UK, that's the main way through which tort liability is limited in the context of warfare by saying that there is no duty of care and there shouldn't be one. My argument there is quite simple. We don't allow soldiers to go on and shoot people indiscriminately. We require that of them in international law. We don't provide them with any kind of authority to do that in other contexts. Why would it be so different and difficult to think that we can just say that there is a duty of care not to act in a way that is consistent with their authority? So that's just that kind of particular point. Towards the end, I come to a comparison between tort law and its alternatives that exist at the moment. Mostly for non-nationals, states offer some kind of payment on an ex gratia discretionary basis. It's usually inconsistent. It's usually done by the very body that inflicted the injury. There are all sorts of other difficulties with it. Usually for the state's own nationals, they have some kind of a quasi-insurance scheme that might operate. I argue that both of these schemes are failing to meet that kind of thing that is unique about tort law, that they don't offer that particular thing, which is turning, as a matter of right, to the authoritative power of the state to try and vindicate individuals' rights, And if we want to move away from that, if we want to limit that, then we need to keep in mind that we're losing that unique ability, and we have to think if that trade-off is a good trade-off. And I don't think that at the present circumstances, we can actually say that that is a good trade-off for all sorts of reasons. So with that, I come to a conclusion, and I say quite briefly that we already have a lot of tort law that is in and around warfare, in the context of warfare. If you have prisoners who have been abused, if you have, for example, contractors who have been negligent, there are even some instances where actual use of force have been dealt with through tort law. So there's quite a bit of tort law that's already done and dealt with in the context of warfare. I don't think that extending it would be pushing the envelope too far. I think that the decision to provide a very wide immunity, nearly blanket immunity in all of these jurisdictions is based on ill-informed policy and ill-informed theory or under-theorization. I think that if countries are really concerned about human rights, about rule of law, about their own legitimacy when they operate, they would want to have tort law as an available remedy that will support their operations rather than hinder them. And I think that generally this kind of argument that is made in this book is part of a larger trend of limiting sovereign immunity, a trend that we have been seeing since the early 20th century. And I think that by adopting the arguments here, we're strengthening that trend and pushing back against various arbitrary decisions that are hard to justify other than populist grounds. So I'm going to stop there. I feel like I've spoken too much.
That's the right amount.
Excellent. Thank you.
Thank you. That's
Perfect.
very helpful. It's very helpful. Carla, do you want to go next?
Sure. Firstly, congratulations.
Thank you.
And I also have to say it's nice to see you. And I say that because Haim used to work at Essex, but he worked at Essex during COVID. So I actually never met him in person during COVID.
Yeah.
And we only met a few months ago, just really by chance.
Yeah.
So nice to see you. Nice to see Hedy as well, because Hedy is also former Essex. And so is Dara. We are all the great people.
Yeah.
Big request there.
We've also never met in person.
No, I don't think so.
Anyhow. So firstly, congratulations on the book. It's great. My background, particularly the work that I did at the NGO Redress, was all about helping torture survivors to seek remedies, reparations for the harm they suffered. Many of the victims we dealt with were victimized in the context of some type of conflict, whether a non-international armed conflict or an international armed conflict. So the starting point for me is that this push to see tort law as applicable in the context of conflict makes a lot of sense. But from that perspective, I would say human rights law doesn't really feature so much in your book, and it could do more in terms of the connections, because the right to a remedy stems from human rights law to an extent. And I would say the separation of whether or not human rights law is relevant in the context of law, there's been a lot of shifts in that respect. So I would think there's a lot just to draw on or further. Is it a good idea? Is tort law helpful? Absolutely. From a pragmatic point of view, absolutely. You have governments who are deciding whether to engage in war and how to engage in war. If you can't review those decisions and the harms those decisions cause on often very vulnerable individuals, vulnerable groups, cultural institutions, then you have really nothing. If I think of the work that we did over years in relation to the UK military's engagement in Iraq, for instance. If there was no access to the courts to deal with issues such as the harms caused by military action, you would have no accountability whatsoever. So my point with that is that tort law is already applying, particularly when there is some kind of relationship with human rights law. Should it apply more? 100%, because without it, you have only one kind of narrative, which is applying, which is the narrative of the state about its actions, which fall within a sphere of justification. Tort law is important because it's about access to court. So to me, that I think is the most important point. With respect to the issues, I would say the book, your book operates, we think about a book and how it operates, how it engages with issues. I found your book quite interesting because it operates at quite a high level, quite a theoretical level, as opposed to a nitty-gritty detail level. You have some of the detail, but I would say you're very free in the book because you're looking at theoretical concepts and how they operate together in a way you're not constrained by case law or case judgment X or law Y. They're not really, you're not feeling bound by that. You're thinking more creatively, critically about the normative role for tort law in this. And I think that's really interesting and that's really important. One somewhat tangential point, which I bring up because when I was reading the book, it kept on coming to me. You have something that I noticed in the book, which is quite interesting. If we think about gender pronouns, and I know this is a completely tangential point, but it comes up in the book. You have changed, or you have used female gender pronouns throughout the book, which is an interesting approach, which many scholars are increasingly starting to do, instead of using male pronouns with the view to, we don't want to over focus, or we don't want to pretend that the only people who exist are men. But think of it in the context of what you're writing about. So when you're reading, the book talks about the female perpetrators throughout the book, and it's really quite interesting. Because we know that in the context of conflict, women and girls are not normally the perpetrators, they're the victims. But because of this flip of gender pronouns, it gives a really interesting flavor in terms of a book, which was a little bit surprising, but quite interesting from that perspective. So it would just be interesting to note. The central part of your thesis, as I understand it, and as you've articulated right now, is that tort liability should be available for belligerent wrongs, which you define as wrongs that stem from a breach of international humanitarian law or a breach of the rules of engagement. I think the one thing to note, and I know you've written on this elsewhere, that there's a whole constellation of harm which exists outside of these parameters. And I think in a way that could be even more clear, that when we think about, for instance, the remedies that sometimes states provide by way of little payments, usually they're providing those payments not in the context of tort law, they're providing those payments for people who are injured, not without it being a violation of international humanitarian law. So the kind of the innocent injuries, if you take it from that perspective. So I think in a way that is something perhaps that I noticed. I think also there's a natural tension, at least I find that there's a natural tension when thinking about Who decides what is a belligerent wrong? Is it the state? Usually it is the state. So if we think about any example, and we all have different examples in our heads of horrific conflicts, which cause horrific harms. We all have our own examples. So if we think about that and we think about the rationale, the public rationale of the state is either going to say, what? Well, the actions that I did, that the state did, were fully compliant with international humanitarian law. They complied with principles of distinction, etc. And so that's one thing. Or they're going to take a very broad view of the rules of engagement. So from that perspective, in terms of your framing, in my mind, the issue is not that only those categories should be subjected to a tort analysis. It's more that the categorization itself needs to be subject to adjudication. And I don't think you don't say that, but I think in my mind, the issue is not really about how to adjudicate the harm. It's how to adjudicate whether there's a harm. And for me, just in terms of the different cases that I have looked at, it's always about the justification. The states are justifying their actions. They're not debating about the level of their liability. And I think that's probably something you agree with, but it doesn't come across so crystal clear in all respects. I absolutely agree with you on the issue of combatant immunity, that it should be abolished or significantly narrowed. I think this is really important. I think it's used progressively as a cover, just for the purpose of avoiding any kind of accountability, and to put forward principles of combatant immunity without coming up with some alternative is really unconscionable when you think of the level of the harm. And this is really what it's all about, because it's not as if the other kinds of remedies that are being put forward are by any means adequate. They're absolutely not. They are charity, they are simple, limited things trying to get an issue out of the newspapers. It's not about the victims, and what needs to happen is that these matters get to court so that you have an impartial, well, assuming that the courts are impartial, which is not obvious, but you have an impartial avenue where these cases can be adjudicated. So I would absolutely agree with you that with respect to that. A question I did have has to do with your focus in on moral arguments. As I understand it, you're arguing that the focus in on IHL breaches and breaches of the rules of engagement is important because it gives the moral underpinning for compensation. But I wonder whether you actually need that, because morality is somehow, in the context of the rules of war, so skewed in favor of the state already that I don't know that that is necessarily something that you need to ground your arguments in. I think IHL has some natural flaws. I don't think it's the be all and end all, even though it's a very well tested legal framework. I think it can be critiqued. And then there was a very narrow point that, you know, when you're reading and all of a sudden something comes and it sticks. And it was an interesting example that you provide. So I just, if I have time, just going to go through this one tiny example, because I think I analyzed it wrong. But you talk about the situation of any state. You can all think of a state. A state has access to intelligence. They have this intelligence which says that the building over there is full of military targets. Basically, the order is given to the soldiers, go bomb the building. But before that happens, the evidence, basically the executive has new information, and it has plenty of time to tell the soldiers and up the chain of command to change that this isn't a valid target anymore, but it doesn't do it because it's negligent. So in your analysis, you talk about this case, and I mean, there are some cases which look like this in reality, and we know, and we're probably all thinking of different cases. So the first thing you say, at least the way I understand it, is that the soldiers themselves are not responsible because they were acting on the information that they have. And that I absolutely agree with. But then you talk about the executive, and here's where I'd really like to get your point of view, because you kind of say, well, the executive didn't really give the order. So it's not really responsible either, because it was the chain of command in the military who gave the order. So in a way, the responsibility isn't there. But to my mind, you can't really separate the negligence of the executive from what ultimately happens. At the end of the day, it's all pulled together with state responsibility. So that's really my question for you, is how do you avoid state responsibility? And if you have state responsibilities, surely you must have tort liability. If not, the articles on the responsibility of states, very clear, if there is a wrong, there's got to be a remedy. So maybe I'll stop there. But thank you. You've made me reflect a lot, so I'm very pleased.
All right.
Thank you very much, Carla. A lot of food for thought. You have some time to think about that further. Emmanuel?
Thank you very much. My comments are not going to be as rich as Carla's, so be forewarned. I'm thrilled to be here to celebrate Haim's book. Thank you very much for the invitation. I come at this from two angles, the two angles that are combined in the book. I began my career and my sort of academic life as an international lawyer. Several years ago, my thesis was examined in this very building by Malgosia, who's in the audience, and for her sins. But ever since I went into academia, they told me, well, international law is not really law. You have to teach something that's proper law. So they gave me tort law. And I fell in love with that and have been ever since. So I come across a book, Tort Liability and Warfare, and I get excited. Both parts of my personality get excited. The first thing to say about Haim's book is that it's an incredible achievement because tort lawyers have not gone there before. I mean, there have been article length treatments, which you do engage with. But the level of engagement with warfare in tort theory has been minimal. And I think you're really filling a gap, or more likely opening a door for future work there. And that's an incredible achievement in itself. My comments are going to focus on the theoretical underpinnings of the book. And Haim says straight away that he is endorsing an idea of torts as wrongs. So the idea, which has been around for a long time, in many instantiations, the one you endorse is, broadly speaking, the corrective justice approach. So that a tort is the violation of a right, that is a wrong, and there's a principle of corrective justice which says that the wrongdoer must now make repair for the wrong that has occurred. And you're saying very plausibly, well, warfare doesn't change this basic idea. It may place certain limitations on it may create certain nuances as to whether there is a wrong. It may throw up all sorts of complications about causation and duty, and certain points about immunity, which you do accept. But warfare doesn't change this fundamental picture. I should say that, and this is a further distinctive feature of the book, which I really appreciate, that while some defenses of the idea of corrective justice and the idea that torts are wrongs have been overly formalist in character, this is not your approach, or at least as I understand it. So in its first instantiations, the idea that torts are wrongs was supposed to be a truth about the structure of tort law. Like, unless you understand torts as wrongs, you're not understanding what you're looking at. And Ernest Weinrib has defended a view of that idea, which says that I'm not necessarily, saying that there are no other ways of dealing with wrongs, or there are no other alternatives to tort law. But if I look at the common law of tort, I just see certain formal features. There's a claimant and there's a defendant, and there's a court that responds to the claim by determining that the defendant is a wrongdoer who must now make repair. These are not random assortments. These are not random phenomena. And that if we attend to the form of the tort action, we can see that there's sort of corrective justice happening here. A more substantive conception of corrective justice, or a more substantive conception of tort law as responding to wrongs, is not formalist. It says that tort law is there to achieve a certain kind of value, to achieve a value that may be perhaps achieved in better ways, but it's distinctive about tort law because tort law is the best way of getting at that value or articulating it. And I think, as I read you, in your conception, that has tort law has an expressive function. So it is a very important part of tort law that it allows claimants to hold defendants accountable for their actions in the special way of one person holding another accountable, rather than one person being the victim who then turns to the state and says, I have been the victim of a terrible misfortune, please help me. That is a useful form of redress in many situations, but it doesn't have that distinctive quality of holding another person to account. Now, if I'm right in reading your approach to corrective justice like that, this already has, I think, a major payoff, which is that you're not, you can speak to people who are outside tort, in tort theory. You can speak to people who are worried simply about accountability or rights violations. And you can tell them why you think that tort law is the best tool we have for getting certain things done. But there is a price that I think comes with that. And a price that we do recognize, but I think that the challenge is still there. So, and this point speaks to your comparison between tort actions and alternative regimes like ex gratia payments and insurance payouts in Chapter 7. Before we started, I thought it was Chapter 6, but it is Chapter 7. And in Chapter 7, you lay out the different features of ex gratia payments and insurance payouts in different jurisdictions. And you note the differences between systems that pay out nationals and systems that pay out non-nationals and the different grounds of that. And then you say, well, compared to those, tort law has the advantage of allowing claimants to hold defendants to account, has this expressive function. That's fine. But the end position is one in which the benefit, the advantage of ex gratia payments and insurance payouts is that they're fast, they're quick, and they're easily accessible. The advantage of tort systems is that they allow for individual accountability. They allow an individual to stay in court. They involve adjudication, which is much more responsive to rule of law values and constraints. But the basic position is that there are pros and cons. And if there are pros and cons on both sides, that means that trade-offs are acceptable, where these trade-offs should be, on the table. And this is where I think you can sort of either push the envelope a little further. And I would invite you to say whether you do think that accountability is the core value here, that if there's a clash, we should go with increased accountability, the accountability that tort law offers, rather than the sort of fast, cheap, and easy to process alternatives, or whether you're actually open to sort of normatively open to contestation here. You do say in the book, and this is actually one of the aspects that I appreciated, that there will always be an empirical backdrop to these claims. But I want to ask you whether you have sort of a normative, what you think the deeper normative agenda is here. Are you willing to accept trade-offs and say that, well, achieving corrective justice and giving individuals this mechanism of accountability is important, but it's not the only thing that matters. And maybe there is a ballpark of possibility for different jurisdictions to consider. And a second sort of ancillary point, and I'll close with this, is this. I wonder what you would say to someone who would argue that insurance payouts have their own expressive function. So I'm thinking here, the main insurance model in tort law is New Zealand, a jurisdiction in which for personal injuries, there is no tort litigation. Everyone who gets, who suffers physical injury in New Zealand, be it because they slip in the bathtub, just their own stupidity, someone else negligently falls on them, they suffer a traffic accident. There's no tort litigation with, the person that wronged them. They just go to the ACC, the Accident Compensation Corporation, and they get their money. Like an insurance scheme, this involves caps, involves certain requirements, but it is much cheaper than normal tort litigation, especially in the UK. I'm not, I suppose it would be cheaper than Israel too, but you'll inform me otherwise. And one way to look at what New Zealand is doing is not that New Zealand doesn't care about the expressive function that tort law provides, but rather that New Zealand instantiates a different conception of our relations to each other. So the conception that underlies the New Zealand system is more like accidents happen. They are a communal responsibility, and therefore it is part of what we owe to each other to have a fund out of which such compensation is paid. Now, let's say the business end of that observation would be that it is maybe not fair to this position to think of the expressive function, to think of expressivity as the domain of corrective justice alone, that there may be expressive values in the alternative compensation systems too. Thank you so much for producing this amazing work. I think it will be it's a harbinger of developments in the field, and I think will be a talking point for quite a long time.
Thank you so much.
Thank you. Thank you, all three of you. I think it's very interesting to hear both from Carla and Emmanuel, because like the breadth of responses you've received reflects the diversity of the target audiences in a sense. So yeah, you have the opportunity to respond.
Perfect. Thank you so much. I'm going to try and pick at some of the points in order, just because I had a bit more time to think about the comments. So maybe I'll start with a point about gender pronouns, which I thought was a really, really good point. And it was a point that I was thinking about quite actively because I am not a huge fan of the type of discourse that tends to exist in the realm of tort law, which focuses on the reasonable man. And I think, women can be wrongdoers too. But I think you're absolutely right that in the context of warfare, when we think about who are more likely to be at that end and suffer that wrong, and who is more likely to be at the end of committing the wrong, that gender is flipped. And I take that point that perhaps it's not the most appropriate opportunity to try and fight back against the discourse when it creates that. I think that that's a valid point and something to think about and consider whether overall it's worthwhile. But I do like the idea that it causes people to stop and think, which at least it assists in that kind of first point of trying to push back against the mainstream discourse. So the other point that perhaps I want to flag is the point about who decides what will be a wrong, or how would we adjudicate what is a wrong. And I think that somehow connects to your point about whether I need IHL as the kind of the moral underpinning, considering the fact that it's already quite swayed against or in favor of states. And I completely agree with you that generally speaking, when we think about the tort regimes that states expose themselves to, they decide what would be an actionable tort and what kind of exposure that would have. We can see that in ordinary, peaceful, everyday life, with the way there was a shift in the mid and early 20th century from blanket immunity into various forms of liability, and it changes from place to place. So we can see that there is that bit of variation. But I think the reason why IHL and rules of engagement are helpful in this way is because I'm trying to think about a way to explain how we accept as a matter of law that states can do certain things in the context of warfare, right? We allow them to act in self-defense. We allow them to use force. We allow them to injure people, both those that pose a direct risk, but also collateral damage to a certain extent. And we need to find a way to settle that I think is morally consistent and legally consistent. I don't think that it is a matter of sound reasoning or policy to have different definitions of the same thing for different pockets of law, unless there is some really good theoretical underpinning for that. And I'm not sure that there's one that we can find here. I think it's chapter 2 that I'm really trying to go over and think about, okay, we can try and think about it in different ways. Do we have an excuse? Do we have suspension of rights? Do we have an instance where we're overriding rights? And I'm going through all of these possibilities and ruling them out one by one. And I'm left with a conclusion that people can disagree about, and that's absolutely fine, that the only to explain how it's possible for states to act in self-defense in the context of warfare and inflict those terrible losses is if they have an authority to act in that way. So those losses are justified. So I have to think about tort liability in the same kind of way, right? So ordinarily, if we walk in a busy street and you just accidentally brush against somebody, we wouldn't say that's a tort for a variety of reasons. If somebody's a threat to you and you push them away, you wouldn't say that's a tort for various reasons. And I think we need to try and follow the same kind of approach. And in the particular context of warfare, IHL is the way to translate when do we have authority for the states to act in that way. So I think we have to be tied to IHL. I also think that IHL provides a floor. So this is something that states can't unilaterally go below. So although they have discretion to decide on the particularities of their rules of engagement, when will they need authority to do this, or whether they should fire that weapon in that angle at that point in time or not. IHL still provides a floor, IHL is very ambiguous. I think that if we had tort liability that could discuss and think about IHL, we would be able to develop a much richer jurisprudence on what actually it entails, and maybe we can find some unification. But I think rules of engagement will provide a much more direct route to touch and discuss whether the state has acted in that particular instance through its agents, be it soldiers or contractors or something else. If we think about the rules of engagements, they are tangible, they allow this way to think about it. And I think that the domestic courts are in a good position to adjudicate these kinds of claims. They already are doing that in other contexts, at least in Israel. Reviewing these types of losses through the rules of engagement is something that's quite common. In the UK, reference to the rules of engagement and these types of decisions is something that comes up in relation to liability under the Human Rights Act, or immunity from liability in relation to the Crown Act of State doctrine. So I think it's a way, it's a mechanism, and I think it's possible. I think it's plausible, but more than that, I think it's necessary. I find it hard to see something that is a better justification or a theoretical fit in the particular context of warfare, because it is a different moral and legal sphere to everyday life. So I don't think we need to judge things to the same standard. And I think this brings me to your point about the example where you had a negligent intelligence force that provided information, but not the most accurate, up-to-date information to the actual soldiers on the ground. So there is a mismatch here. So I think that we actually agree on this. I think that this is an instance, and this hypothetical is based on an actual case and on an incident that has happened. And I think that if we think about IHL and we try to locate liability just through IHL, we might run into a little bit of a problem if we try to pin it specifically on a particular individual. But if we look at the state as one mechanism, as one organism, an artificial person that can only operate through various individuals, there is a way to say that, no, actually, you are directly liable for this. It's not vicariously liable, you are directly liable for this, because this is how you operate. And it's a different way of conceptualizing how we should perhaps review states, or maybe even organizations, and generally artificial people and what we think about them. So I think there is a way, and in some jurisdictions, you will slice liability to require first identifying the individual who committed a wrong, and then you can only pursue the state vicariously. I don't think this is something that is necessary. I don't think this is something that is done in all jurisdictions or in all legal contexts. And I think that we both agree that if we abstract and we look at the general picture, we can see that the state has been negligent in this context and could be pursued directly. So with that, perhaps I can go to your points, Emmanuel. Maybe I can just focus on two. The first big point was about my academic approach, like who am I as a theorist, right? Am I a Weinrebian, or am I something that's slightly different? I think that I'm something that is slightly different. There is a reason that I chose to follow corrective justice, and I didn't fall into the various different articulations of what that might be, but just kind of in broad strokes. The other main competitor, a main theoretical approach, is instrumental, and through various empirical studies, some conducted by others, some conducted by me, there are very strong indications that when it comes to warfare, the state and its agents just actually don't care about those instrumental concerns. They will always have a lot of money, they have deep pockets, They plan in advance how much money they are going to be spending in litigation for various activities that their security forces are doing. So they actually are not going to be deterred by tort liability. They're just going to calculate how much it's going to be, and they're going to pay for it in one way or another. And if they can't, well, they're just going to bar claims or say that actually security concerns are going to be overriding whatever financial concerns, and we're going to deal with financial concerns later on. So the instrumental approach, I think, in the context, the particular context of warfare, I don't think that it's a good fit. I think that.
But the way you describe
Yeah.
it sounds very instrumental, right? They're just doing the cost benefit.
So that's what I think they're doing in that particular sense. But that only leads you to a certain conclusion that no matter what's going to be the price tag, they're never going to act in a way that's safe or safe enough. So the entire underpinnings of the instrumental approach, trying to minimize accidents and losses and maximize social welfare, that just collapses. Whereas the corrective justice or the rights-based approach, that approach that tries to say there is value in this tort law that goes beyond whether we minimize accidents and maximize social welfare, the intrinsic value, that sticks. And at the same time, I want to say that yes, we can have trade-offs and we need to consider them. And I think that generally rights-based approaches, peoples, would agree with that. They were not going to say, no, we have to have tort law no matter what. It has to exist. We welcome trade-offs. We accept them. They might say that we're not doing tort law in that case anymore. They might say that tort law is the better option. And if we have a trade-off, we need to properly justify it. And I think that that's the kind of approach that I'm advocating for here, right? I'm saying that due to substantive rule of law reasons, due to rights-based theoretical reasons, right? The strong indicator, the starting point, the default position is that if you commit a wrong against a person, you need to have a remedy. I think you can have a remedy in different ways. The question is what you're losing and what you're gaining, and that has to be accounted for and properly justified. If you're going to take somebody's rights to bring a claim in tort, you have to properly justify it. And I don't think that any court and any legislator has properly justified until now. I think that the justifications have been thin at best and arbitrary and discriminatory more commonly. So I think there could be a wide variety of possibilities. I think that those that exist at the moment are not doing great. Yes, they provide quicker payment, but that payment is inconsistent. Access to it varies, really depending. Could be varied and depending from location to location by the same country. So they have different brigades at different places and different JAGs, military attorneys that will provide different instructions. So I'm not entirely convinced by those alternatives. When it comes to insurance, the state's own insurance, like New Zealand, right? You said two things, and I thought they were interesting. One, that does it have an expressive value? And the other was that by simply having it, you have an expressive value of community responsibility. I think that those are really interesting points. I think that those are points that I'll struggle to deal with in a very abstract theoretical way, but I'm going to try. So the question of whether these types of insurance payments have some kind of an expressive value. When you get a ruling from a court in tort, that ruling says you wronged somebody or you didn't wrong somebody. When you get a payment from these types of insurance claims, what you usually get is you are eligible according to the criteria. It doesn't have the same kind of expressive value as a tort claim. But it does have, I think, the expressive value that you're talking about, this communal responsibility. But I think that tort law also have that kind of communal responsibility, right? We're saying we're going to have tort law. This is our way of saying that if somebody wrongs you, you're going to go to the source of our community's power, the big independent arbitrator, and that person is going to say, you've done something wrong, you're responsible, fix it. So I think you have both of these mechanisms that have this kind of expressive communal responsibility value, but one of them has a much stronger value in its execution than the other. So whether or not you're going to prefer one or the other might want to factor that in, as well as the other points about how easy it is, how accessible it is, whether it's cheaper. I have to say that dealing with courts, I think they're horrible and take a long time, and they're not geared towards the individual, as opposed to bigger, stronger, more sophisticated players that have deeper pockets. So I would think that I'm very sympathetic to moving things away from courts and into other avenues. But at the same time, when it comes to warfare, if we think about communal responsibility, then, and this ties back to Carla's point about bringing in more human rights notions and norms in. We can see quite a few quasi-insurance things happening in relation to a state's own nationals. It's very hard for states to go that extra step and say that humanity is one big community that we should all be responsible for. Or alternatively, something that's a bit thinner, to say that we are not going to impose losses on another person for the sake of our community. We're not going to get them to shoulder that cost when they are entirely innocent. So I think that the risk with moving to a New Zealand regime in relation to foreign nationals is that it's going to be a lot harder to perhaps convince. It's not something that it's impossible. I think that it could be great if it existed. I think that operating through tort law might be easier in terms of programmatical, a first programmatical move. We're going just to abolish all of these ad hoc immunities and allow people through the courts and see what happens. But I do think that it's probably going to be better if states could be more magnanimous and say, we recognize that individuals have a right to an effective remedy. We recognize that individuals have a human right to life, bodily integrity, and property. And our way of providing that and be accountable for things that we've done wrongly is perhaps by providing them with the best means. The best means is probably not going to be tort law for foreign nationals in these big conflicts. It's going to be something else. And we're going to do that. But until they do that, at the very least, I think we should abolish or at least limit these immunities that cannot be justified. So I hope that that answers some of the questions, but maybe opens the door to more conversation.
Thank you very much, Haim. We have exactly 15 minutes left, so we have some time for questions. Let's see how many questions and comments we have. I know Margosha.
Thank you. I have to say that I am still an international lawyer. I still stick to it. So I have to say that your book is kind of for me an eye-opener, because I always approach warfare from the international law point of view. And why I was listening to the discussion, and I particularly was really intrigued by Carla's comments on general international law, and also I see that it's a nexus of different laws: international law, humanitarian law, human rights law, general rules of state responsibility for a wrongful act, definitely, and then the private law, tort. And I just wondered how it can be reconciled from the point of view of a particular case, how individuals and states approach this nexus of different laws in order to arrive to some acceptable conclusion. How is it is even the enormity of it, I never actually dawned on me, because I have to admit I never took into consideration private aspect of it. And now that's why I call it an eye-opener. But it even makes it more difficult, because we have of action, omissions, wrongful act, attribution of a wrongful act, due diligence, negligence, all that, how it is all brought together to give a reasoned decision which will take into consideration all these elements from international law, national law, put together in a coherent case.
Thank you. Yeah.
I'll just collect
Yeah,
a
yeah.
few others just so you can get as much input as we can provide. Darren?
Yeah, thanks, William. That was great. I really enjoyed it. And I'm glad I came, despite how gorgeous it is outside. So that's really positive. I think it's mad that there's not a book on this before. Like, it's such a good topic. I can't believe it's so well done. And I'm really looking forward to reading it. And I think anything that brings militaries into the court more is a good thing, like both for accountability and forcing them to justify their actions. I have two thoughts that are, I obviously haven't read the book, so they're possibly informed. But one is what you were saying about IHL as the metric. And I think I agree with Carla that today, for me, if you're talking about, I think you're talking about the proper authority of the state, it's the law that binds them. And for me, it would definitely be the co-application of IHL and human rights law. It's not like talking about bringing norms in from human rights, but actual human rights law and figuring out how it applies. And I think that would be particularly important in like two contexts. One is in the non-international armed conflict and in situations of occupation. And I think the risk is that if you just look at IHL as the metric, you go to the extreme kind of examples, and then something that wouldn't be wrong under IHL, but should be, is a wrong if you apply both bodies of work, but and the second one is on rules of engagement. And I can see where you're going with it. I think my issue with rules of engagement is that in principle, you have the lovely 3 Venn diagrams and everything fits under the law. I think in a lot of cases, the issues with rules of engagement is that they go beyond the law. And so it should be IHL first and rules of engagement means to interpret them. And I think the second one is a more difficult one, and maybe comes back to the other points about sorry, I'm rambling now, I'm really tired. It comes back like, how do you adjudicate it? Because that's always the question, isn't it? You shoot somebody in the back of the head when their hands are tied behind the back, easy enough to say they're wrong. And the much harder one is the middle ground. And I think the difficulty with rules of engagement is that they'll be good at illustrating don't execute people, but really much harder in that, what is a military objective? Is this attack lawful or not?
Yeah, I'm just going to throw another very different set of questions at you. But I agree. I think it's. I'm amazed that there isn't a book on this. Actually, it's great, and I'm great to see. So I'm kind of thinking, and I really applaud your honesty about the instrumentalism and the deterrence. There's a lot of dishonesty, I think, in discussions about international law right now. People justifying their own kind of agendas to say, well, this will be a deterrent, this will be an instant deterrent, and this will sort everything out. And I'm thinking particularly of a debate I'm involved in around an ecocide law, all kinds of hot air just around the proposal to make ecocide the 5th international. But anyway, that's another debate. So I thought that, but I'm also thinking that you're rooting this then in a kind of better rule of law or just equitable remedy kind of rationale. And I suppose my question is that enough, right? Because the question for me in those questions being more into kind of more of a sociology of law, which, if you like, is well, what does this mean for struggle? What does it mean for social power? What does it mean for social struggle? What would this mean for social movements, actually? And if I think about, like, I'm not convinced about Iraq. I'm not convinced that some of the cases that came out of the Iraq War did strengthen the social movement against the war and against the ongoing occupation. And I'm not convinced that in Israel right now, whether to be prosecutions on, whether to be tort actions on this basis, that would have it might even have a counter. This is the danger, isn't it? Sorry, this is a long question, but this is the point I'm getting to. So I'm very influenced by the Irish Scottish revolutionary James Connolly on this question. When there was a debate about making dum-dum bullets unlawful in 1915, and he says, well, what happens then? And I think that the essay was called "Can War Be Civilized?" What you do when you outlaw dum-dum bullets, you make all these other. He talks about shrapnel. Well, shrapnel bombs suddenly become legitimized, much more brutal form of warfare. So that's the critique of that's from a critical legal studies perspective of international law of law. It also has a productive capacity. It doesn't just have a capacity for establishing a rule of law. It also produces other things which are not so. That's the hidden danger, isn't it? If you focus on, my question is then, is this a useful, do you actually think this would be a useful way to build social power, or would it undermine social power in the context?
Can I just say, because in a sense it's almost an impossible ask to expect to address all of these challenges, but these are very important questions. I'll just say, having read the book, in a sense, the book is both very ambitious and very modest. In the way because you say throughout, I think it's especially in the introductory and the concluding chapter, I'm not going to say too much, but I'm just kind of mediating this. You're saying what you're not doing, you're explaining why you're not doing it. And in that sense, it's very modest, and you're also saying what the framing of harm is and what it's not. So yeah.
Perfect. No, I think it's important, right? Because as Margosha says, right, and I think Carla mentioned as well, right? There are so many different ways of tackling this issue, and this issue has mostly been addressed through IHL or IHRL, almost not at all through tort law and private law, and in trying to articulating a single way of viewing and showing why tort law can be a relevant thing, then I was just very much focused on tort law, its internal structure, its theories, and how we can find a way, how we have to actually communicate and think about those other bits, mostly IHL, in the most extreme of circumstances, where it's that body of law that does the main body of work to try and kind of explain the state's authority and demarcate it. And through that, try and bring this kind of a coherent argument to show why we should have tort law. But I think, Margosha, you're asking a very good question, one that I'm not dealing in the book, and one that I think is a very difficult one. And it's how do we settle these different bodies of law that compete and can lead to possibly different results. I think that the more I look into different bodies of law, the more I see how they're inconsistent. And I'm not entirely sure that we can have a system where everything is unified internally and internationally. So I'm not sure that I have a very good answer in how do we reconcile this. I think that the answer that I'm trying to give here is that currently individuals are lacking a power that they should have. They don't have a voice. They can't stand on their rights. It's up to their states to try and decide whether they're going to try and do something, and how, even if they succeed many years later, how are they going to funnel the funds? And I think we're losing something there, and I think they should have a voice and they should have that ability. And how do we reconcile? Maybe we'll get the people in the UN, if it sticks around for the next few years or so to try and figure that out. Once they adopt, of course, all of my recommendations, and now they have that urgent problem of trying to reconcile all of the different bodies of law. But I think it's a very complicated one. I think that some people that I think Emmanuel mentioned have a very particular frame and viewpoint of wide areas of law and how they could all be unified. But even then, reading Weinberg's new book, right, you will have different pockets. You will have a way of thinking consistently about private law. You might have a way of consistently thinking about public law. It will be more difficult to have a consistent way of thinking about all of the different areas of law, and then also take into account the way that they've actually happened in reality. Dara, you asked really good questions. You're welcome. I think the point about IHL and human rights law, take both of them. I think this ties to that point, right? I'm looking at the most extreme case and say, well, if the most extreme case can have that, and that extreme case mostly is the most relevant thing for authority, at least in my view, and we can disagree, would be IHL, then all the other cases that would be less extreme, well, we can just deduce, right? And say, yeah, we can take those things, right? We can take the building blocks, find the relevant authority, source of state authority, and figure out from there whether something can be justified and non-wrongful or not. And eventually, if you think about things that fall short of actual combat, those are things that are already covered by ordinary tort law. Courts don't turn to human rights law to address that. They turn to ordinary tort law principles, right? Was this person falsely imprisoned? Was this person battered? Was this person was there trespass on that property or destruction of that property? So I'm not entirely sure whether in the particular context we will even have to turn to human rights law for things that fall short of actual hostilities. And I get the point that many countries don't see eye to eye with me about what the IHL does as a floor, and there are lots of disagreements here. And I think those are just those things where, because there are disagreements, we can try and tackle things in different ways. If it's any consolation, I can say that there are so few cases outside of Israel that talk about these kinds of things, whereas there are hundreds of cases in Israel that talk about these kinds of things. And you have hundreds of cases where rule of law principles have been examined in a lot of detail. They have gone to looking at the type of ammunition that was used. They looked at the angles where something has been fired to try and figure out actually whether the state has exceeded its authority and was negligent in that conduct. So I think there is a way to operationalize things using the rules of engagement in a way that I think is a lot easier than even IHL, because it is much more controversial and amorphous. And I think maybe that brings me to David's point, your last point about whether it's going to empower people. I think not having the ability to bring claim in tort is definitely disempowering people. I think that having that ability is a way to at least try and have a check about use of force, and the state's using its power. It will have lots of challenges. It could have a lot of political backlash, but I think it is an important mechanism, and it is one that I can see that the more it was used by foreign nationals, then the more backlash there was, and try and limit their access and limit the court's ability to review state action for the particular purpose of disempowering those foreign nationals. So I think that there is a lot of promise here, because it will bring things to the fore. It will provide a voice and a platform for people to try and express the experiences they've had, to try and push back against abuse of power and misuse of power, expose it, have some kind of a historical record, some kind of narratives, whether it can help in the broader question broader political movements, I am not entirely sure, and I think that really depends on the context. But I can tell you that the sheer fact that so many countries have decided to move away from blanket immunity in tort into a regime where they can be sued in tort was based on social, political, and economic movements. And I think those generally succeeded. So I think there's a lot to talk about and think about, and I think there's potential here as well as risk.
That's the next book.
The next book is something completely different. Yes.
The one after.
The one after is going to be torts and other baked goods. Stay in touch.
Something to look forward to.
Exactly.
Thank you to our panel.
Thank you.
The drinks, rather than coming before the event, came during. So
Wonderful. Thank you. And thank you for everybody online as well.